Hi, everyone. My name is Shawn Joost, and I'm an employment law attorney. I've been practicing primarily in the area of employment law for the last several years, and I'm a partner in the employment law group at my law firm here in Sacramento. So since I'm a lawyer, I have to show you my legalese here. Got our waiver. But today we're going to talk about what we like to call swords and shields for employment law claims. And we're going to cover several categories of employment law claims that are, traps for the unwary employer, and hope that we can help you protect yourself against them and help you defend against those claims if someone alleges them against you. So I am going to do my best to manage the question box. So you can feel free to put in a question in the box. And generally, I like to go in at the end of each of my little sections, and I'll look at the chat box and answer questions, because that just makes it a little easier for me to manage. So I will do my best to get to everybody's questions, and hopefully we'll have time at the end for some questions and answer as well. So we're going to start with some common wage and hour claims. Those are the most common because they apply to everybody, right? They're going to apply to every employer. So first of all, when we say wage and hour claims, what do we mean? We mean that they are claims that arise from violations of the California Labor Code or the wage orders. And sometimes they'll come from the Federal Fair Labor Standards Act, that's the FLSA. But in California, our labor code provisions in general are stricter and more protective of the employees. And so in those cases, you have to follow the state law instead of the federal law, but the federal law still applies. And if there are occasional areas where the federal law is stricter than the state law, then you have to follow the federal law. And I want to just take a moment to pause and talk about wage orders, because I often have clients ask me, what is a wage order? And if you don't know what your wage order is, that's your homework to write down for today, is to go and read your wage order. So what wage orders are a type of regulation. And if you go to the Department of Industrial Relations website, dir.gov, I think, you can just search in there for wage orders. And there are a whole bunch of them. Some of them are what we call industry wage orders. And an industry wage order means that if you're in that particular industry, for example, there's a mercantile industry wage order, everybody who works for you is going to be covered by that rules set out in that wage order. If you're in an industry that doesn't have an industry-wide wage order, then you're going to have to go and look at the occupational wage orders. And that means that people in your company, depending on their occupation, are going to be covered by the rules that are in different wage orders. For example, in the construction industry, there's no industry-wide wage order. So you have to look at, for example, wage order number 4, which covers professional managerial type folks. And then you'll have to go look at wage order 16, which covers construction workers who actually work out in the field. So that's just a couple of examples, but your wage order gives you the basic rules for what I think of the building blocks of setting up your wage and hour and payroll practices. It's going to give you the rules for very basic things like overtime, minimum wage, hours worked, meal periods, rest periods, split shift pay, uniforms, expenses, very basic things that you need to understand about your wage order. And a lot of the provisions and a lot of the wage orders are the same, but there are some differences. So you have to make sure that you're looking at the right wage order. But that's your homework for today. If you don't know what your wage order is, it's one of those things that's posted. It's included in those mandatory posters you put up. So it's hanging around your business somewhere. I hope it's supposed to be. So I encourage you strongly to go and read that. So wage and hour claims will deal with things like overtime, meal and rest breaks, capturing all hours worked, and also, are you correctly classifying your workers? And we're going to talk about that in two different meanings of classification, both exempt versus non-exempt and independent contractors versus employees. And wage and hour claims can be brought into different forums. They could be brought in court, you get sued, or your employees could go to the labor commissioner and they can have their claims heard in the labor commissioner forum. So it's two different ways to have those addressed. Why are they so expensive to defend? The reason that they are expensive to defend is that they are considered strict liability claims. So it doesn't matter what your intention was. If you thought you were paying everybody correctly and you wanted to pay everybody correctly, but you were failing to pay time and a half overtime or hours worked over 8 in a day, you broke the law and your employee is entitled to those unpaid wages. So it doesn't matter if you didn't know or you didn't mean to, it's an unpaid wage claim and the employee is entitled to recover. There is a very complicated penalty structure if you violate the labor code. And so there are penalties that you pay sometimes to the worker. And then there are also penalties that get paid to the state of California. For example, if you make somebody work through their lunch, you owe them an extra hour's pay, but you're also potentially liable if the labor commissioner were to investigate. There's civil penalties that you might have to pay to them. If your employee sues you for unpaid wages or unpaid meal period premiums or giving them a pay stub that doesn't have all the required elements, all of those are wage and hour claims. If they win, they're entitled to their attorney's fees. They are also the type of claims that lend themselves to class actions or private attorney general act claims, which are both types of representative claims that are brought against employers. And if you have insurance coverage for a wage and hour claim, it's only going to pay your costs of defense. You're never going to have coverage for the underlying liability because, as I said in the first instance, it's a type of unpaid wages. So for example, you could get insurance to cover you against, let's say, harassment claims. And if you had a harassment claim, your insurance company would actually cover the damages, the payment that's going to be made to the employee in addition to the cost of defense. But that's not true with wage and hour claims. So it's more expensive for you. So how can we shield ourselves from wage and hour claims? So some critical items that every employer needs to have. First of all, basic building block, your employee handbook. That's going to have all of the laws, the compliant policies with laws, and also some best practices. So for example, the law says that you have to give your employees their lunch period before the end of the 5th hour of work. And as long as you had that in your handbook, you have a policy that complies with the law. But best practices would go further than that and say that you want to include in your handbook that, for example, if employees fail to follow that policy, they could be subject to discipline. And if employees are prevented from taking their lunch break for a work reason, that they should report that to their supervisor so that we can pay them that extra hours of pay. So you want to make sure you have an employee handbook that has everything in it that the law requires you to have and also has best practices that will help shield you from those claims. You want to have every employee sign an acknowledgement saying that they got the handbook and that they understand that they are subject to the policies in that We highly recommend that you have employee sign arbitration agreements. And that way, if someone does want to bring a claim, they can't sue you in court. They would have to go to arbitration instead of sue you in court. Now, there are some carves out of those things. There are some things that you can't force to arbitration, but you can require most employee claims to go to arbitration. And the most important protection that you get from that is you can include in your arbitration agreement something that says the arbitrator can only hear the employee's individual claim. So it gives you a waiver of class actions or other types of representative claims. So that's a big help. Then time cards, an often overlooked building block, very important to have good timekeeping. And particularly, you want to make sure that your employees somehow sign the time card. Now, most people don't use paper time cards anymore, so you may not have a physical signature, but there will be some way that you can have your employees certify that the time that they're submitting is correct. And that way you have a record that shows they approved of the time, so that if your payroll is called into question, you have that evidence. And finally, exit interviews. Again, something employers often overlook. Exit interviews can be really useful tools for two reasons. First of all, a good exit interview form will have questions about whether the employee sustained any workplace injuries that they haven't reported, whether the employee believes that they were treated unfairly in any way, whether the employee agrees that they've been paid all wages that they were owed. And that's helpful in two ways. So first of all, if somebody says, no, I don't think I've been paid everything, and then you got an issue that you can try to wrap it up then. Maybe they have some vacation pay that they thought was coming to them. Whatever it is, it's good to know that in advance so you can try to take care of it on their last day of work. If they say, no, I wasn't treated fairly, my manager is always using racial epithets. Well, you want to know that and work on cleaning that up. The other reason it's important is if somebody signs off and says, yes, I got everything I was owed. No, I was never treated unfairly. Everything was hunky-dory here. And then a year later, you get a lawsuit claiming that they were harassed and they were owed all this money that they weren't paid. The fact that they signed off on the exit interview form at the time of their termination is evidence casting some doubt on their credibility. So it has two benefits. So some of the bigger claims for wage and hour, we're going to go through and talk a little bit about them more specifically. First claim, uncompensated time or unrecorded time. So all of your non-exempt employees have to record their hours of work. So they need to know what time did I start work? What time did I go to lunch? What time I come back from lunch? What time did I leave at the end of the day? You, the employer, it's your job to keep a record of all those times. So you can do it on an app on the computer. It can be on a time clock on the wall. It could be on a spreadsheet. It doesn't matter what you use, but you have to have that. So an issue that comes up a lot is time that employees claim is not accurately reflected on their time card. And it could be for a lot of reasons. So some examples are unrecorded time, de minimis time, which is like a tiny bit of time. But that's become a very big issue in employment litigation in the last couple of years. So the examples we're giving here are computer boot up time. So a case recently came down where the employees, they have to use their computer to work, but their time and attendance system is on the computer, and they have to turn on the computer every day. And as we all know, it takes a minute or two sometimes to get your computer turned on, open up the program where you're going to use to clock in, and then the employee clocks in. And 2 to 3 minutes might go by between the time they start that process and they're able to clock in. So that's unrecorded time because that's considered time worked. They're getting their system up and running, but they couldn't clock in yet. The same thing can happen at the end of the day. For example, I have client who just has a big class action lawsuit. One of the claims is that the employees have to log out on their computer. That's where their timekeeping system is. They log out, and then before they leave, they have to secure the building with a security system. And that takes 2 or 3 minutes for that to happen. And then they leave. So there's 2 or 3 minutes at the end of the day that's not showing up on their time card. So that's a big issue. It's something you have to think about. Sometimes it's just a practical consideration, how to record that time. It needs to be done. Travel time is another good example. Sometimes clients don't realize that time that employees spend traveling, say they're working at a particular job site, and then in the middle of the day, they have to drive to another job site. Sometimes clients don't realize that that's time worked, and that should be part of the normal workday, not excluded. But I've run into businesses where those employees do not record the travel time as time worked. They only record the hours where they're actually on the job site working. So that's another instance of unrecorded time. Another way that uncompensated time comes up is from a rounding policy that is inequitable. And what rounding means is that if your employee comes in and they clock in at 7:52 in the morning and they clock out at 5:01, it's hard if it's a manual timekeeping system to calculate the actual number of hours. So what we do is we say, well, we're going to round it, right? If you clocked out at 5:01, we're going to consider that you clocked out at 5. So that 1 minute is not being paid for. But on the other hand, if you clocked in at, excuse me, at 7:48, we're going to round that to 7:45. So then you got 3 minutes pay for 3 minutes you didn't work. So in that case, the employee lost a minute on the back end, gained 3 minutes on the front end, and the courts would look at that and say, well, that's okay, because it doesn't always go to the employer's benefit. So there are 2 reasons to look out for that. Reason 1 is, under the law on rounding policies, it has to be fair. And that's looked at over time, over all the employees. But if you don't check every once in a while, it's hard to see sometimes if it really is being implemented fairly. So it's tricky to do that. But number 2, over the past 6 months or so, there have been some new cases coming down where courts are saying you don't need to round anymore because you're using this electronic timekeeping system, and it will calculate for you the exact number of hours and minutes that the employee is working. And since it's calculating it for you, you need to pay for that. There isn't some scribe at their desk having to figure out, the amount of time from 7:47 to 5:01. I'm sorry, I've got to. Okay. Not a convenient time for this. Anyway, so rounding policies, if you're using one, first of all, I would recommend that you look at the reasons you're using it and try to figure out if you can dispense with it. Because I think they're going to be going by the roadside under the law. But in any event, if you have to use it because you're still maybe using an old manual system, you really need to check it periodically and make sure it's being implemented fairly. Next item here is falsified time cards. So, for example, I've had this happen where supervisors know that they're not supposed to let their people work overtime without approval from a higher manager. But the supervisor's under pressure to get the job done and has his crew work until 5:30, but he tells them, look, you all, we're going to write 5 o'clock. And so then you've got a bigger a really big problem because you've got big chunks of time that are uncompensated. And last but not least, auto deducts. People ask me if they can do this all the time, and the answer is always no. So let's imagine you send your landscaping crews out into the field, and before they go out into the field, they come to the warehouse to pick up their equipment, and that's where you have your time clock. So they clock in the morning, then they're out in the field all day. They come back and they clock in at night, but they haven't been able to clock in and out for lunch because their time clock is back at the warehouse. But the payroll people look at their time for the day and they automatically deduct a half an hour because they're assuming that they took their 30-minute lunch. So that's an auto deduct. And that is a really bad idea because basically you got a time card that says a person worked 8.5 hours and you got a pay stub that shows them being paid for 8 hours. Where did that other half hour go? It's an assumption that the person took lunch. There's no proof that he took lunch. Nobody knows if he took lunch or what time. So it's a very bad practice to have an auto deduction. And it also violates the labor code provision that requires you to keep track of all hours worked. And it specifically requires you to keep track of the time in and out for meal periods. So you want to review and correct any errors in your payroll system. And you should do that at least once a year because things fall off the tracks, and make sure that it's being done correctly. And a way to take some affirmative steps, your sword, is to train your supervisors. They're the number one line on your timekeeping system because they should be reviewing people's time records. And also you want to discipline employees who violate policies. So if you catch somebody falsifying their time card, obviously that's a big one, but also in particular for unrecorded time, that can come up in a lot of ways. That, let's say the supervisor calls the employee at home for 5 minutes just for a question at night. Well, that's work time that should be recorded. And both of those employees should be disciplined, the supervisor for calling them and for not telling them to write the time down, but also the employee who failed to record the time that he was working at night on that 5-minute call. So you want to take that very seriously. All right, claim number 2, meal and rest breaks. You are required to authorize and permit your employees to have meal and rest breaks. For a meal break, you get a 30-minute break if you work more than 5 hours. And you have to take that break before the end of the 5th hour of work. So it has to start no later than 4 hours and 49 minutes into your shift. If a guy works less than 6 hours, you can agree to waive the meal period. It has to be in writing. And then if you work a longer day, of course, you get the second meal period. Okay, is that my... sorry. Oh no, now I've really done it. No. All right, hold on. I'm not so great at these technological things, but I felt like we missed a slide. So, okay, sorry. So breaks. What are some ways to protect yourself against a break claim? Again, training your supervisors and employees on the requirements for when they need to take their break. That should be spelled out in your handbook. That's one of those policies. You want to make sure that you actually relinquish control during the break. So you can't tell your employee, well, you have your 10-minute break, but you have to stay in the break room. You can't leave the premises, right? They have to be free to do whatever they want to do. You have to require them to accurately record their meal break times. When I see a bunch of time records that all say went out for lunch at 12, came back at 12:30, every single day for every single guy in every department for the whole year, I know those are false, right? That's not the way people are. So you want to make sure people accurately record their meal break times and require them to let a manager know if they're denied the opportunity for their break, and you want to make sure you pay that extra hour pay. And to take more affirmative action, you want to discipline employees who fail to take their breaks. So if you see employees who are constantly clocking out at 5 hours and 10 minutes, that shouldn't be happening, right? They're supposed to take it before the end of the 5th hour. So that's where your supervisors come in. When they see that, they need to talk to that employee and find out what's going on. First of all, why are you doing that? And discipline the employee for not going on time. You want to use a timekeeping system. This is a more aggressive approach, but it's a good one, and a lot more people are doing this. A timekeeping system that prevents people from clocking in early coming back from lunch, so that you don't end up with a bunch of time records that show 27-minute meal periods. You want 30-minute meal periods. You can set a schedule for meal and rest breaks, and that way you can make sure that the schedule complies with the law. And if people aren't complying with the schedule, again, you can write them up. But if you take away the self-scheduling aspect, it puts you in a better position to ensure that people are taking their breaks on time. And if there are untimely or incomplete breaks, you want to investigate the reason. Why did you take your break late? If it's because your boss made you work late to finish something, then you have to pay them that extra hour. If it's because they wanted to go to lunch late because they wanted to meet their friend who works across the street and they couldn't go till later, then they're in trouble for violating your policy, but you don't owe them an extra hour of pay because they voluntarily chose to go late. All right, let's see. Okay, I don't have any questions on that, so I'm going to move on to a very big area of confusion: misclassification. So first, we're going to talk about independent contractor versus employee. And, that's been in the law, big changes in the law over the past 2 or 3 years. And there was a lot of talk about it initially, but it's still a source of confusion for folks. And I could do a whole webinar on just independent contractor classification, but I want to talk about some of the basics for you today so that you know what to think about when you're classifying your workers. So the simple test that was adopted in the law a couple of years ago is called the ABC test. And so in order to be an independent contractor, the worker has to meet these 3 A, B, and C criteria. So I want to look at part B first, because that is the easiest one to answer. And when clients come to me with, is this person an independent contractor? This is what we look at first. And if they don't meet all 3, they're out. So let's start with the easy one, right? So the test is the worker must perform work outside the usual course of the hiring entity's business. So you're the hiring entity, right? So you want to look at what you're asking the person to do and look at what your business does and see if it's in the usual course of your business. So for example, if you're a pool maintenance company and you have got a lot of new customers all of a sudden, and you don't have enough employees to go and service them all. So your friend also has a pool maintenance company, and you decide you're going to hire a couple of his guys to come over and help you service some of these customers. If you hire them directly, and probably if you hire your friend's business directly, they're performing the work that's in the usual course of your business, and they should be hired as employees. And it doesn't even matter if your friend is separately incorporated. Under some circumstances, he could be considered your employee. So that's different than if you want to hire someone to develop a website for your pool company, right? You hire somebody to develop a website. Well, website development is not what your normal business is. So that person might be able to be classified as an independent contractor. So question B is the one that is the easiest to answer. And frankly, most of the time when people ask me about these questions, we look at question B and the answer is, oh, no, they're not performing work outside the usual course of my business, so they're not going to be an independent contractor. But if they are performing other work, then you also have to pass test A and C. Are they free from control and direction of you, the hirer, for their work, both under their contract and in fact? So you can't just paper over it. Like, it has to be a real independent relationship so that the person is being hired to produce some end result, right? Some project, and you're not telling them how to do it. They're doing their own business, so they know how to do it, and they're going to go and do it. So maybe like might have an outsourced bookkeeper, and she has her own bookkeeping business, and you don't tell her how to keep the books. You don't ask her how long it took her to do the work. You don't pay her by the hour. You just pay her whatever she charges every month to do your books. She's doing it on her own. And then C, the worker has to have that independent business. So if our outsourced bookkeeper, so far she's looking pretty good, right? I'm not a bookkeeping business, so I passed B, and I'm not telling her what to do, so I passed test A, but now I'm going to look at test C. The worker must be engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So that means my bookkeeper has to have her own bookkeeping business, and she has to have other customers. If I'm her only customer, then the law does not consider her to be engaged in an independent business, and I don't pass the test. So she actually has to have that business going on. Now, second classification type is exempt or non-exempt. Exempt, if you say you're exempt, it means that you're exempt from certain of the wage and hour requirements. For example, you don't get overtime pay, you're not entitled to that meal break or those rest breaks. You don't have to keep track of the hours that you work. The main types of exemptions, and you'll find these in your wage order, are for executives, administrative, and professional exemptions, as well as outside salespeople. And please note this last point, because people get tripped up on this all the time. If you put someone, people say, well, they're on salary, as if that makes them exempt. Putting someone on salary does not make them exempt. Don't think like that. So I always try to refer not to hourly employees versus salary employees, but exempt versus non-exempt, because you can pay a non-exempt person on salary. Like, you could have a receptionist. Clearly, she's not exempt. She's not a high-level executive or administrator. She's a receptionist. You can pay her a salary, but the law is going to look at that. They're going to take her whole salary, and if she works full-time, they're going to take 40 hours, and they're going to calculate that out to an hourly rate. And if she works 9 hours one day, she's supposed to be paid 1 hour of overtime. And you can set that up in all sorts of different ways. But she's never exempt. So you always want to be careful of thinking like that. So here's an example of the administrative exemption. And this is what you will find in your wage order. And you have to meet each of these requirements to be exempt. You have to have duties and responsibilities involving office work that's directly related to your management policies, your company, or your general business operations. And then there's a school thing too, but that doesn't matter for you. So let's take, for example, your controller, right? That's a person who's doing office work that's related to your general business operations. That's different from, let's say, the sales manager who is performing the work of your business and selling things to your customers. This is a person who's administrative. They're handling your internal operations. And that they customarily and regularly exercise discretion and independent judgment. So they have to be operating at a high level. You have to let them make pretty big decisions. And the third is that they're regularly in directing, assisting the proprietor, that's you, that's the owner, or another executive or administrator. So it has to be someone at a high level who's performing those kind of administrative tasks. These last two are important, and you'll find these in the executive, administration, and professional tests. And all the wage orders, I think all the wage orders. You have to be primarily engaged in duties that meet whatever the exemption is, in this case, the administrative test, but primarily is a specific thing. It's a time question, and it means more than 50%. So at least 51% of your time you're doing your exempt duties. That doesn't mean just which are your most important duties. It means literally, did you spend more than half your time on it? And then you have to be paid a monthly salary of at least 2 times the minimum wage. Very important. Just had an email from a client, a new client today. I just learned that you have to pay double the minimum wage to be exempt. So it sounded to me like she probably is in a lot of, got a lot of people that she needs to fix their classification. So some shields for, oh my goodness, I'm so sorry. For your exempt versus non-exempt test, accurate job descriptions are key. And that's because you want to be able to look at what duties do they have, and then you can kind of look at the list of duties and you look and see, am I giving them that discretion and judgment? And are most of these duties exempt duties so that I can figure out that they're spending more than half their time on them? And for independent contractors, it's very important to have a written contract that spells out all the terms and how they're being paid and what the product is that they're producing. Some swords, some affirmative steps you can take to protect yourself are to perform some audits. So for your exempt employees, you want to audit their duties and make sure that their time is not tipping in balance so that their non-exempt duties are taking up more time than their exempt duties. For independent contractors, you want to periodically audit their duties, but also whether their business is still operating, because remember subsection C of the ABC test, they have to have their own independent business. So I've had clients who have independent contractors and they never check in on them. 3 years down the road, it turns out, they get audited by EDD and they learn that their independent contractor hasn't had any other clients but them for 2 years. So the person is wrongly classified and you got a big problem. All right, now let's talk a little bit about pay stubs. This is an easy one to get right, and it's one that a surprising number of people get wrong. So the labor code has a list of things that have to be on everybody's pay stub. So here's the list, and here's the last of the list on the next page. When you get off here, your second piece of homework is to get out one of your company's pay stubs, get one for a non-exempt employee, and get this list for my slide and check, look at your pay stub and make sure it has all these things. And don't think to yourself right now, well, I have a payroll company doing my payroll, so I'm sure it's correct. Do not think that, because that is far from true. Most pay stub errors that I see are from payroll companies. They do what you tell them to do. They don't go in and give you advice on what the labor code requires. So you've got to have, things that you might think of, and some of them you might not think of. So you have to show the gross wages, the total hours worked for your non-exempt folks. If you have piece rate, that's hard to manage, but you can have it. You got to show the number of piece rates earned and the piece rate that you're paying, all the deductions, and then the net pay, the inclusive dates of the pay period, not just the end date of the pay period. So that when I look at my paycheck, I should see this paycheck covers from this date to this date. I want to have both on there, and the employee's name, and then either the last 4 of their social or an employee ID number, the name and address of the legal entity that is the employer. This one gets done wrong a lot. If you're using a DBA, your DBA is not your legal name. your pay stub needs to have your legal name and address, all the applicable hourly rates and how many hours the employees worked at each rate. And then finally, your paid sick leave. Everybody has to have up to at least 24 hours of paid sick leave. It should be on the pay stub. You are allowed to put it on an attached sheet, but why you would, have some separate sheet where you're putting payroll on your pay stub every week, I don't know. It's much safer and better to put it on the pay stub. So some shields, you want to properly retain your pay stubs for 4 years. So if you get a claim, or if your employee asks you for a copy of their payroll records, which they're entitled to, you can provide them. And payroll reports are not the same as looking at your actual pay stubs. It's much better to keep your pay stubs so you can show that they were always correct and had all the categories. If you use electronic pay stubs, you want to look at the labor code and make sure you comply with the employee access requirements. There's a detailed list of things that you have to cover. And again, don't assume you're in compliance just because you use a payroll service. And a SORD is again to do an audit periodically. Sometimes things get changed in systems, or a new payroll person comes and something changes that nobody notices because they don't regularly audit. So, at least once a year, you should audit your handbook and your pay stubs to make sure that they are in compliance. Okay, claim number 5, untimely final payment. You have to pay people their final paycheck at a certain time. So if you fire them, you've got to give them their wages right then before they go. And that includes any unpaid vacation or unused vacation. If they quit, but they give you at least 72 hours notice, you still have to pay them then at the time of separation. If they quit without giving you notice, if somebody comes in on Friday and says, today's my last day, you have 72 hours from when they gave you the notice. You have to include any accrued vacation, and you have to deliver that final paycheck in person to them unless there's a signed writing that gives you other instructions. Do not wait until the last or the next payroll. People frequently say, well, I gave them their last paycheck. I just ran it through that week's payroll. It's late and now you owe a penalty. So that's the biggest problem I see with that. So understand and abide by those requirements. You can retain evidence, right, of when you made the payment. What's the date on your check? You'd be surprised again at how often the check date is wrong. The check date is 2 weeks later, even though they actually paid them that day. So make sure you have evidence, and to be really, affirmatively trying to protect yourself, you can get the employee to sign an acknowledgement, like a receipt. I got my paycheck, number whatever, the amount of whatever, so that you have that in the file in case they later claim that they didn't get their final wages. Okay, so those are the big claims that we're going to look at, that we looked at. And I want to share some information here about resources that our firm makes available to anybody who wants to sign up. We have 2 things. We have a monthly podcast that drops. It's never more than 5 minutes, and it's always on some, employment law that's new, or a trap we can't see people falling into. We want to give people a little refresher. It's a really simple way. You can just listen to it, on your way to work in the morning. It's a nice way to keep up on things. And then we do a quarterly employment law newsletter that talks about any changes in the law, updates, reminders. And so those are resources that we make available so that people can stay up to date on employment law issues. And I invite you to feel free to go onto our website and subscribe to that. But we've got time here for questions. So does anybody have any questions? We covered a lot of topics, and I know that there's usually a lot of questions. So happy to answer any of your questions. I think you can put them in the chat box. or in the Q&A. I know somebody has questions. If you don't ask questions, I'll think of more homework assignments for you. Okay, I'm watching my chat box to see if anyone types anything in, but all right, so I'm gonna think of some.
Dawn,
Yeah,
since we have a minute, I'm going to ask a question. Is something
okay.
something that I have seen come up is a correctly classified exempt employee supervises a number of non-exempt employees, and there is turnover in the non-exempt employees, and there is a time lag between the time that a person leaves and the time they hire another person. So the exempt employee performs the duties of the non-exempt employee that is gone.
Mhm.
I'm fairly sure from what you said that you need to audit that and make sure they're still doing 51% of the time they are spending as exempt duties. And that's a question I see coming up all the time.
That's a really good question. So yes, that would be a situation that I would recommend that the person really audit what's going on. You know, how long is this time lag taking? And also, and this is a little harder to give an objective answer to, but why is the manager doing the tasks? So, and the reason I say that is a common area where this misclassification question comes up is something like a manager of a restaurant or of a retail store. And they're usually classified as exempt, but they spend a lot of their day, let's take the retail store, stocking the shelves, walking the floors, looking at the displays. And are those exempt duties? And the way that the courts look at that is to say, well, there's a difference between your clerk that comes in, stocking the shelves, just unloading the box and putting the stuff where he's told to put it, and the manager walking around and stocking the shelves for the purpose of assessing what's the layout, are things in the right place, is this how I want things to be set up? So you can't just assume that because someone's doing something that might be the same task as their clerk, that it's for the same purpose. So you're not necessarily going to lose your exempt status, but I agree with you. It's something that you want to review. And especially if you're talking about 2 weeks and I'm performing some of these duties to keep the place running, but also so I can have a better understanding of what are the tasks, how can I recruit for this task, you're probably in good shape. But if we're talking about a 6 months gap, you know, then you've got a bigger problem. So that is a good question. And that line between exempt and non-exempt can flip. It is possible for someone to be exempt 1 week and not exempt the next week. So you do have to keep an eye on what your exempt folks are doing, especially if they're on the edge or in a situation like you just described. That's a good question. All right, looks like we've got some hardy souls here having some questions. Is there a good way to outsource this? To outsource your HR function? I'm going to assume that's what we mean. Yes, there are companies who are HR consultants, and I often do recommend to my smaller clients, if they don't have enough employees to warrant hiring their own full-time HR person, I do recommend that people retain an HR consultant, because first of all, they'll come in and they'll get you set up right. If you could get set up right, that's half the battle. And then as things come up, believe me, trying to manage if someone has to go on a leave of absence, or they have a discrimination claim, or they claim they're not being paid right, you want to have a professional that you can call to manage some of those day-to-day things. You don't want to call your lawyer for those questions. Well, some people do, but they do. But I always tell them, like, you're paying me a lot. I think you could do this cheaper. But so I do think there are a lot of good agencies like that can help with that. Let's see, I have employees that have lunch off site and they write in when they come back at the end of shift. Excellent. What must I do to enact a policy to waive their lunch if they choose not to take it? Okay, so they can't waive their lunch unless their whole shift is less than 6 hours, okay? So if they're working less than 6 hours, they can waive their lunch. It has to be in a written waiver agreement. It can be ongoing. So if you have people with short shifts, then they can sign that paper. It goes in their personnel file. It's there forever until one of you rescinds it. And of course, if people work shifts of less than 5 hours, they don't even get a lunch. So other than that, you cannot waive it, even if they want to. This is so important. This is an important point. People often come and tell me, oh my gosh, I have all this labor claims and blah, blah, blah. But my employees wanted to do it. They agreed to do that. They asked to do it, all of which may have been true, still illegal. You cannot waive your rights. Most of the rights under the labor code cannot be waived. So goes for lunch breaks and a lot of other things. Additionally, I've worked for a corporation that has a 7-minute grace rule. So 7 minutes from the quarter hour will round to the nearest quarter hour. So the entered payroll is, oh, that's the rounding policy that we talked about at the beginning. And that's not illegal as long as it's implemented fairly over time and across all employees. But I'm just saying we're seeing the writing on the wall with some recent cases, and the courts are saying, why are you rounding? You have a time clock that calculates it for you. Most people have that now. So that practical need for rounding is disappearing due to technological changes. And so I tell my clients, and my newsletter this quarter says this: if you're still rounding and you have something other than somebody's manually calculating, you better stop rounding. And if you're manually calculating, I would look strongly at why you're doing it that way and see if you can't change it. So is it a good policy to implement? No. It's a policy that's going to be, I think, probably it could become illegal soon. So if you're still using it, do away with that and get an easy to operate, accurate electronic time system. Let's see, for exempt pay, double minimum wage, is that the state minimum wage? Is there an assumption of 40 hours per week? Yes, that's correct. So you figure out that the person is working at least 40 hours a week. That's what that's based on the state minimum wage. And so you're going to pay double whatever minimum wage. And this year it was a big jump because it went all the way to $15.50. And for small employers who were still in that phase-in period, they had a $1.50 an hour jump. So I had a lot of employers who didn't want to make that big of a salary increase for their exempt folks. And so they converted some of their exempt people to non-exempt. Let's see, anything to be aware of for converting someone from exempt to non-exempt, since I suspect we are, okay. So yes, and that's complicated. It's definitely something you can do, but what your concern is that if you convert someone from exempt to non-exempt, in general, you open yourself up potentially to a claim that, well, my duties haven't changed, so why are you converting me? I must have always been misclassified. Now, at this particular moment in time, with this big jump in the salary minimum, that gives you, that's your legitimate reason. And it sounds like that is your reason. Well, I just can't afford to pay you that threshold anymore. So I'm going to have you classified as non-exempt. Now, be aware, you're now going to have to pay them overtime. So if they've been working 50 or 60 hours a week, it might not save you money to convert them. You'd have to run those numbers, but that's the biggest thing to be concerned about. And let's see. Oh, I thought maybe another one that popped in there, but okay, so we did that. We did that. Okay. Any other questions that anybody has? How are we doing on? We got 5 minutes, so if anyone else has a question, they can
While
jump.
we're waiting, Shawn, I'd just like to thank you for soldiering on with the sore throat. We really appreciate
Yeah,
it.
I don't even have a sore throat. I don't know. It's just like a tickle in my throat or something. So I was at
Oh,
this.
and I also need to tell people they will receive a copy of the recording and the slides. And you just did to have one more question come in.
Oh, would I do a webinar employee manuals? Oh, that's a good topic, actually. I think we might even still be looking for a topic for our last webinar of the month, but yeah, what are the things that you should cover in employee manuals? Yes. That would be a good one. Don't try to write it yourself. That would be pretty hard to do. That's something you need a an HR professional or a lawyer to do. And like your pay stubs, don't just take that employee manual that your payroll company offers you, and use it, because it won't comply with California law, I guarantee you. But that's a good topic. I'll make a note of that. That's a good idea. All right, well, this was fun. I think that's all of the slides, right? Yeah, I did.
Yes.
There's my waiver again. Okay, all right. Well, thanks so much, everyone, for being here today, and thanks for having me. And
Thank you.
see you next quarter.
Okay, bye-bye.
Bye.